the rest of us, it is Saturday evening. So I really appreciate all of you coming here. And today we have, I think, a very unique and unusual conversation, which is a discussion on the book Competition Law in South Asia, Policy, Diffusion and Transfer, which was published in 2023 by Cambridge University Press. And the author of that book is Dr. Darr. And we're going to have sort of a slightly free-flowing conversation around that book. And please do feel free to ask questions from the panelists. So we have an absolutely sort of fantastic set of panelists from across South Asia to discuss Dr. Darr's book and the issues arising from it. Unfortunately, one of our panelists, Mr. Azar, is unable to join us because of the current problems in Bangladesh. There's very limited internet connectivity, so he's unable to join us. But we still have a very fantastic set of panelists, and I'm really looking forward to all of their views on the book. So I'm going to start with just talking very briefly about the book, and then I will introduce the panelists, and then we will hear first from Dr. Darr, and then we'll hear from the panelists, and then sort of we can have a more of a free-flowing conversation around the book. So I really sort of found this book to be such a fantastic study about how the process of adoption and implementation of competition laws in different South Asian countries can impact the enforcement of competition law. The book primarily focuses on India and Pakistan, but also sort of has very interesting insights on Bangladesh, Sri Lanka, Nepal, Bhutan, Afghanistan, and the Maldives. And the methodology of study that the book uses is also, I think, really interesting. So the book, it compares the ways in which different countries in South Asia have gone about adopting and implementing competition law, the legal and institutional frameworks within those countries, and their broader economic milieu. And that kind of study helps to shed light on what makes competition law work in South Asia. And the book has some really interesting insights on that. So for me, what I found really interesting was the fact that the book finds that in jurisdictions where competition law was adapted through a bottom-up process of socialization, what the author calls socialization, which involves stakeholder consultations and consent from the people who will be impacted by competition law. In those kind of jurisdictions, and India is an example of that the author takes, competition law is likely to be more successful in its implementation when compared to jurisdictions where it is adopted through a more top-down approach of what the author calls coercion, where competition law is forced upon stakeholders. And a lot of South Asian countries do have this kind of approach, and Pakistan is an example of that kind of a jurisdiction that the author takes. So that is one sort of fascinating perspective, but the book also has so many other perspectives, including how sort of the success of competition law is also very much impacted by how much the government of a country believes that competition law can really help with achieving social and economic goals in that country, and how much the government puts its weight behind the enforcement of competition law. So it feels like it's very much an ongoing process of government involvement in the implementation of competition law. With that very brief introduction, and I'm hoping that we'll talk much more about a lot of different aspects of the book, I'd like to introduce our speakers for today. Dr. Darr is a lecturer in competition law at University of Manchester and a senior research fellow at the UCL Center for Law, Economics and Society. She holds a PhD in law from UCL and is also a barrister, Lincoln's Inn, and an advocate of the Supreme Court of Pakistan. And obviously, she's the author of this fantastic book that we're discussing today. And we are joined by Professor Aditya Bhattacharjee, who is retired from the Department of Economics, Delhi School of Economics in 2022, where he also served as head of department. Among his other research interests, he has published several papers on competition economics, law, and policy in leading Indian and international journals and has edited volumes. He has published in edited volumes. He has also served on government-appointed committees to propose amendments to India's competition regime. Next, we have Dr. M.S. Sahu, who is the founder of Dr. Sahu Regulatory Chambers. He earlier served as a distinguished professor at the National Law University of Delhi. He was a chairperson of the Insolvency and Bankruptcy Board of India, a member of the Competition Commission of India, the Secretary of the Institute of Company Secretaries of India, a whole-time member of the Securities and Exchange Board of India, and an economic advisor with the National Stock Exchange of India. As a member of the Indian Economic Service, he has served several ministries in the government of India and also has served on the boards of several organizations. He has also led several expert committees. Next, we are joined by Mr. Sameer Gandhi, who is a partner and co-founder at Axiom 5 Law Chambers, LLP in New Delhi, which is a boutique law firm that advises on issues of competition law and public policy. He has served as counsel to the Competition Commission of India, has appeared before the Indian Parliamentary Standing Committee on Finance to comment on amendments to India's competition law, has advised the Karzai administration on the then Islamic Republic of Afghanistan on formulating its consumer laws in a 2010 DFID funded project, which I think is also discussed in the book. He serves as visiting faculty at the National Law School of India, University, Bangalore, where he teaches a course on competition law and practice. He received his BA LLB honors from National Law School of India, University, Bangalore, and LLM from the London School of Economics as a Commonwealth Scholar. Finally, but this is a very significant presence in our panel today, we have Dr. Shahryar Hamid, who is an assistant professor of corporate and commercial laws at Sheikh Ahmed Hassan School of Law at LUMS in Pakistan. Dr. Shahryar has held the position of assistant professor of law at Warwick Law School, UK. He has been a senior lecturer at Coventry University Law School. His writing and research is in the area of corporate governance and financial laws. So I'm so excited to welcome all of you to this discussion. Thank you so much for being here. And I'm really looking forward to hearing from all of you about the book and more broadly about competition on South Asia. So we'll start with Dr. Darr. So Dr. Darr, tell us a little bit about what you think are the primary insights that South Asian countries can derive from your book as they evolve economically and politically in sort of this climate where things are changing, particularly, for instance, in India, we know that we're at sort of this cusp of a lot of discussion and debate about whether we should adopt a new law a new competition law, for digital markets. So what can your book tell us about what we should do or not do in this process?
Thank you, Shilpi. I'd just like to begin by thanking everyone for being here. It's a rare privilege and honor for me to be in such wonderful company and in South Asian company, I might add. I think it's probably the first time that we are having a discussion on competition law, which is really just between scholars and practitioners and experts from the region. And I think it's not only amazing that Shilpi, you were able to pull this off, but I also hope that this will not be the only discussion we have, and there will be more opportunities going forward. It is a shame that our colleague from Bangladesh was not able to join, but of course we understand the circumstances were beyond anyone's control, really. But I will try to plug that gap a little bit by talking about Bangladesh specifically in this conversation as well. So thank you again for the excellent summary of the book. I always appreciate when somebody else reads and tells me what they got out of the book, because the proof of the pudding is in the eating. But I will take this opportunity to just to highlight a few points. I think there are many more. This could be a longer conversation, but I just want to pick up the sort of low-hanging fruit. So as you rightly mentioned, Shilpi, I've been talking about the core argument in the book is that the process, the strategy, the mechanisms, the institutions through which a country adopts its competition legislation has a strong impact, a significant and discernible impact, rather, on the way that the law is implemented. Perhaps not the only factors influencing it, but certainly significant ones. The 8 countries that I study in the book are at different stages, as it were, of the deliberation, enactment, and enforcement continuum. So whilst India and Pakistan have proceeded to enforcement, Bangladesh is at the brink of enforcement. I think it's perfectly poised to commence enforcement. Other countries, and we won't talk about each one in too much detail, but they're at different phases for different reasons. The insights that I'd like to highlight should be relevant to different countries, depending on where they are in this continuum. But I will also end by speaking of Bangladesh specifically, and of course, the Indian sort of move towards an amendment. So at the deliberation stage, the key insight that I have to offer is that countries should be looking for deep compatibility, which means not compatibility which is superficial in terms of, do we understand the words? Are they is this kind of matches with what we've been doing in the past because of the IMF or the World Bank instituted reforms, but really thinking about how this competition legislation relates to other trade restrictive practices legislation that might be existing. How does it relate to the institutional framework in the country? How does it relate to the enforcement strategies that countries have adopted for similar laws in the past? I think one of the difficulties that legislation such as the competition legislation has is that it doesn't resonate with domestic audiences. By audience, I don't just mean consumers. I also mean people who are in the know, the legislators or the government officials. They don't really understand this language. So it is important to bring about this deep compatibility. Not only in choosing the models that you study, that you pick to sort of develop a competition law, but also in how these models are adopted. In a lot of South Asian countries, in fact, in all South Asian countries except India, we saw a heavy involvement of multilateral agencies in this regard. But I think the more aware that the South Asian countries are of the need for this deep compatibility / legitimacy, I think they will be able to bring a more meaningful response to those discussions at the deliberation stage. At the enactment stage, my sort of key focus would be that it is really important to involve as many branches of state in the legislative process. So the government, of course, puts the bill, brings the bill to the government. We saw, to the parliament, as we saw in India. The parliament then has, of course, the standing committees that go out and discuss. And I think that discussion is critical, not only to build a broad-based ownership of the law. So everybody realizes that they have a role to play. For instance, if what is the role of the judiciary as well? What is the role of the adjudicatory bodies? But I think that's also important for successive governments to take ownership, because it is not just the brainchild of one person or one particular government that had a particular relationship with a multilateral agency, but the machinery itself is behind that law. And I think that really makes a difference when it comes to establishing enforcement authorities, when it comes to appointing members, and when it comes to allocating budgets. At each stage, at each government change, that question is taken up again. And I think that kind of broad-based consultation supports that going forward. A fourth stage that I highlighted in the book, which is the hiatus stage, which is where a lot of the countries, especially I think Bangladesh, found itself that it had adopted the law, but it had not proceeded to enforcement. It had even set up a competition authority of sorts, but it had not proceeded to enforcement. And it's quite easy to dismiss that as a dead stage, but I see it as a stage full of possibility. And I saw India in that stage as well when I was observing that there was a gap between the first enactment and the subsequent enforcement. But the possibility that I think that India somehow recognized, and that I think Bangladesh also recognized for that matter, is that that is a stage where you can actually use the tool of advocacy to create not just a sort of understanding of competition ideas with the stakeholders by going to meetings and sort of holding meetups with different stakeholders, but you're also signaling to the government that we have a role to play, we are important, and we are here, and we have a function to perform. So I think that I feel that whoever grasped the possibility of that stage has actually helped themselves going forward. I think India certainly did. Of course, I always have a difference of opinion. That with my Indian colleagues that, this could have been done better. I always feel it has been done reasonably well because I'm comparing it across the region. I think India is looking at itself in sort of as a single entity, and I see it in a comparative perspective. Bangladesh, I feel, has also done some of that, especially during COVID. We saw the Bangladeshi Competition Authority making some noise about the price of foodstuffs and everything. And I think that has helped in what I now feel is they're very well poised for enforcement. And we're seeing more advocacy now, at least in academic institutions. They're introducing courses on competition law. There have been some articles that are being published in competition law for international journals. So I think there is that movement over there. Finally, at the enactment stage, at the implementation stage, what should be a priority? I think this is something that Dr. Bhattacharjee and I have also talked about. He's rather talked about it to me that, the priority setting, the goal setting is very important. And I would endorse that. And I would also add that it should be goal setting in the broader framework of where the country sees itself. So not just to enforce competition, but to enhance the country's competitiveness in the global economy. And I think that is many more factors come into play. How are we looking at the socioeconomic indicators? How are we looking at our role in sort of, human rights, labor laws, climate change. I mean, competitiveness is a much bigger basket, but I think we are very low in a lot of South Asian countries rank low on human development or competitiveness. And I think that is where the focus should be, that competition should not be an end in itself, but it is a tool and a vehicle that takes us towards our true goal, which is enhanced competitiveness and a bit better human development outcome. Now, I think all these considerations are important for India as it looks at entering the digital age. Of course, India is looking at the foreign models for, the report that was published, and I've had a chance to review it. So we look at the EU model, or you're looking at the UK DMCC model. That is always important. It is important to look at foreign models because there's no merit in reinventing the wheel when it exists. But I think what is important to also understand, to stretch the metaphor, is what is the state of our roads? What kind of wheels will run on our roads, and not just getting a perfect wheel. I'm saying this to the converted. I think India does understand that, but I think what might be important here is to really have even deeper understanding of it, to really understand where is the Indian digital sector, where do we want the Indian digital sector to go in the next decade, 2 decades or so. And I think those considerations should inform how we adapt the law. And of course, never losing sight, I feel, of the other broader considerations, because, what's the point of a competitive economy if it's not trickling, or I shouldn't even say trickling down to, but if it's not manifesting itself in improved conditions for our citizens. And I think that is not something that we worry about so much in the West, because we have a lot of other institutions to take care of those considerations. But when we don't have those developed institutions, and I think it falls to all institutions to step in and do that. So that's sort of, I've tried to wrap it up in a nutshell. I hope this is enough to start off a conversation, but I'd be happy to jump in, and a lot of examples from South Asia on each of these points, and I'd be happy to bring them up if and when that becomes necessary.
Thank you so much, Dr. That was
Can I just
brilliant.
interject and say, please call me Amber? I'm more than happy to just be called Amber. Okay, thank you.
Thanks, Amber. So, I mean, I think that was a brilliant sort of take, given the limited time that you had on sort of the various facets. And I think even for India, there are important takeaways in what you said. And I think we can have a lot of discussion on each of the points that you've highlighted. So I will now sort of open it up for our very distinguished set of panelists to give their opening remarks, where I request you to, given sort of your extensive experience, your unique perspectives, I think all of you will have very different and sort of your own takes on Amber's book. So I will ask you to please tell us what you thought of the book, what parts of the book resonated with you. Did you have any differences of opinion with anything that was argued in the book? Sort of what would be your sort of initial takeaways and reactions? And if you could also maybe shed light on what you think about sort of the perspective that Amber's book kind of takes in the learnings that South Asian countries can have from each other with respect to competition law, and to what extent you think that regional developments within South Asia can impact the growth and development of competition law. So I will first call on Professor Bhattacharjee. The floor is yours.
Thank you, Shilpi. In view of the short time, well, first of all, thank you for inviting me along with these very distinguished panelists, three of whom I've known for many years. I've known and respected their work, and very happy to meet for the first time Shahryar and hear his views from across the border. And I have actually prepared a short PowerPoint to keep me strictly to time, because as a professor, one tends to talk too much. So I'll just share it. And it seems screen sharing has been disabled. That's okay. I'll just keep it for my own reference. Right. So the key takeaways, I think Amber herself and Shilpi have given us the key points very concisely and accurately. And in terms of reactions, well, I have to admit that I had a slight advantage over the other panelists in that I was asked by the publishers to review an early draft and write a blurb for it. So I've seen the manuscript from an early stage, and I've seen how it has been refined and polished into this amazingly comprehensive and clearly written survey of developments across no less than 8 countries. It's difficult enough for someone to keep track of what's happening in a single country over a period of decades, but Amber has managed to do it for 8 countries in the region, many of which are at different stages of what she calls the adoption and implementation continuum, many of which do not have enough publicly available documentation for a researcher to figure out exactly what is happening, but she has managed to cull out enough data, if I may use a quantitative term, although much of it is qualitative, to summarize the developments across all the 8 countries and fit them into a unified theoretical framework. She has also shown tremendous familiarity with the economic structure and policies of all the 8 countries, because that is an important aspect of her analysis in order to establish that competition law cannot be transplanted without taking into account the context in which it is to be implemented. And as the only economist on this panel, I can also say that I admired a very effective use of economic data and her use of charts and diagrams, which is very rare amongst legal scholars, and quantification of legal cases and depicting them in graphs, which is extremely rare in legal scholarship, as far as I know, and I try to keep abreast of it as far as possible. Now, in terms of, I don't really seriously agree with anything. As Amber said in her opening remarks, she has a much more favorable opinion of developments in India than many of her Indian interlocutors, and I have been one of them. And so my only, shall we say, disagreement or caveat in terms of where I would like to see further work being done, either by Amber in a second edition at some point, or by any other researchers who are listening into this discussion. I think there are 2 points on which the argument in the book could be strengthened. One is in trying to pose India as more what she calls participatory, inclusive, and bottom-up process of adoption of what she calls a socialization process, in contrast to the other countries where it was top-down and exclusive. I think that contrast may have been somewhat overstated, because the coercion which she has brought out as far as the other countries are concerned, in terms of the role played by, in particular, the WTO and other multilateral agencies, that was not so unimportant in the Indian case, although not as overt perhaps. But if we go back to the late 1990s, as I'm sure all the panelists here know, and perhaps some members of the audience, competition policy was being pushed very vigorously onto the agenda of the WTO, in particular by the European Union, as one of the 4 so-called Singapore issues. The European Union was insisting that all WTO member countries adopt a minimal competition law with at least sanctions for cartels, and subscribing to the basic WTO principles of non-discrimination, national treatment, and transparency. India at the time was opposing this. In fact, it became kind of leader of a coalition of developing countries, vigorously opposing it, ultimately successfully in having competition policy dropped from the agenda in 2004. But all the while, at home, it was first by setting up the Raghavan Committee, then tabling the bill in Parliament and passing it in 2002. India went ahead and passed a far more comprehensive competition law, targeting not only cartels, but the full spectrum in terms of abuse of dominance and mergers and acquisitions, and subscribing by default to all the WTO core principles. So I'm still mystified as to what exactly was going on. Was India, in a way, playing a double game? Was it compromising with the EU in the hope of getting some other concessions in the then ongoing Doha round negotiations? I think this is a subject which merits deeper research by either Amber or other scholars. The other respect in which I think the case for India's socialization is somewhat overstated is that no doubt all three branches of government, executive, legislature, and eventually the courts were involved, and the law, even before implementation, was evolved accordingly. There was extensive discussion in the Select Committee of Parliament, Standing Committee of Parliament. So in that respect, definitely better than having a purely externally imposed piece of legislation which had no domestic constituency except sections of the government that wanted to acquire international legitimacy. So that's true. To that extent, the Indian process was more socialized and embedded, but it was shallow. If one looks at the debate in Parliament, as I have, and that's again something scholars may like to do, it was strongly supported by the then in opposition Congress party. Some of their leading parliamentarians strongly endorsed the bill because they had been part, in fact, the standing committee had been chaired by a leading member of the then in opposition Congress party. But they just used the parliamentary debate to score points against the then ruling party on other counts. But it was very clear from the discussion that this was a very elite discourse. The leadership of the two parties had bought into the idea of the competition bill, but most of the MPs had very little idea of what competition law is all about. That's very clear from the nature of the interventions. And this is about the time when I was getting interested in competition policy. And from whatever media discussion was taking place, I could see that this was not something which had very deep traction in the Indian polity. And that possibly has continued until the present day with much greater engagement by those who are involved, in particular the Indian antitrust bar and the business press. But still, we cannot expect the kind of embeddedness, say, in the late 19th century, so-called populist phase of American politics, or even the more recent Biden kind of approach to antitrust. And this, I think, will color the way in which competition law is enforced in India. So those would be my introductory remarks, which have been asked. We've been asked to keep ourselves to 10 minutes. Some of this will recur in the answers to the specific questions that Shilpi has posed for later in the discussion. Thank you.
Thank you so much, Professor Bhattacharjee. And I have so many follow-up questions for you, but I will hopefully get a chance to ask them later. But as usual, like so much of what you've said is thought-provoking. So thank you. Next, I will request Professor Sahu to share his opening thoughts.
Thank you for having me here. First, congratulations to Dr. Amber Darr for an absolutely fantastic work, insightful work, and probably the first of its kind I am seeing, though I am not a regular scholar in the area of competition, but not seen this kind of intensive work. And the context setting, what you have done, I fully agree with the context. I endorse what Professor Bhattacharjee told, in the sense that India's reforms model has been quite unique. And this competition reforms or competition law has been a part of a comprehensive economic reforms. Though we had a phasing, in economics, basically we talk it freedom to start business, freedom to continue business, freedom to discontinue business. These three phases broadly we had in the decade 90s. The first one, freedom to start that is the 90s, and actually major reforms that happened in 90s. In fact, that was no way directed by IMF, World Bank, or ADB. It was completely homegrown, though not the it was still top-down approach, but it was homegrown and it was a necessity. There is no other option than to do that. And substantial liberalization of, we had the erstwhile law called Monopolies and Restrictive Trade Practices Act. In 91, 92, that was substantially liberalized and completely junked in along with the Competition Act when it came in 2000 or so. Then the focus came to freedom to grow at marketplace, compete at marketplace, and then in the decade 2010, middle of the decade 2010, the focus shifted to freedom of exit. So three major planks we have gone through, but this was sequential. This was a part of one comprehensive integrated plan. It's nothing that it came up sometime in 2000. We wanted to do competition reforms. It happened sequentially. And of course, which Professor Bhattacharya was giving the entire background and parliamentary committee, all those things. We overcame the barrier in 1991 itself, when the both opposition and government all were together, though it was not explicit in 92, it became explicit a little later, but the back channels were open among the ruling party and opposition. They all were on one path, reforms has to be done. So again, there is some rhetoric outside, but all were on one path that we will move together. And in fact, that's why the competition law reforms came during the other government. The main reforms 92 came with the Congress government. Competition reforms came in the BJP government. Insolvency reforms, freedom of exit came in the BJP government. But there has been a side step sometimes, but there has been no U-turn or back step in any of these reforms. Actually, the focus has been, there's a term people use, in the decade 92, in the decade 90s, we not only focused on reforming the market, but also focused on marketing the reforms. Huge investment in marketing the reforms. So once you get into market economy, competition reforms comes within it as an integral part. So road was clear. We moved on a path. Again, it was still, though we had committees. Recently in 2023, there was a committee based on which competition law changed. Recently, there has been a committee on digital law of which Professor Bhattacharya and one of the partners of Samir were also there. There has been adequate consultation, and possibly we have much more consultation in other areas than we have in competition. In fact, those who may not be knowing, there's an agency in India which has started awarding the agencies which do best public consultation. And you know, probably the public consultation index has been developed now by UN UNIDROIT. So a lot more consultation happens in other areas, much less in the case of competition, but still there's a competition. It is still top-down approach. Somebody decides that there will be a committee, they are given a mandate that do this. But there is, as much as possible, a lot of engagement. That's why I use the term that the marketing the reforms, so that we get a general consensus on this. And it was not, in fact, there's a joke that the competition law has been slightly different, but other laws as part of reforms, we have borrowed certain aspects. It was not IMF World Bank dictated, but several aspects have been borrowed. Sex securities law in India we have is broadly based on United SEC pattern. Insolvency law broadly based on UK pattern. Competition law broadly based on European Union, but there has been indigenous approach to that. There has been some plus minus, as Madam Silpi was talking about, we have to see our road condition, what will apply, what will not. Those have been done. We have liberally borrowed, in fact, from, at least because I have spent longer time in the securities laws. That's why there's the joke that when we had the Security and Exchange Board of India, so we borrowed the name Commission, we borrowed the name Exchange from United Securities Exchange Commission. we borrowed the name board from Securities and Investment Board of UK, and we added the word India. So then it became Security and Exchange Board of India. So we have taken contents, but not that's how it has been dictated by somebody. It has been completely homegrown. And fortunately, by the time we came to competition law, we had reasonably mature institutions, which is your other major plank of the work, that how does it gel well within institutional framework. In fact, I don't know how much of economics, but Professor Bhattacharya would know, there has been a lot more emphasis on institutional economics in the recent years. And we consider a kind of a trio of institutional economics. There is a famous book you may be knowing, Why Nations Fell by Acemoglu and Robinson. These two, coupled with one, Arvind Subramaniam, who was chief economic advisor in India recently. These three have done substantial work, and they talk about this, how institutions make a difference. The primary drivers of economy are these institutions. Not that a country has natural, human, and financial resources, but why does a country have these resources? It depends on the institution. So by 2000, we had several institutions, like the basic things like the rule of law, or even this, many problems were sorted out. Like in the earlier days, there is a big struggle whether a regulatory body can impose a monetary penalty. It could suspend or cancel registration. That is normally a cricket club does, any club does. But in 1995, after a lot of negotiations, finally, Government of India agreed that we will empower Security and Exchange Board of India to impose monetary penalty subject to 3-4 conditions. It was done, and thereafter it has worked. But this solution was replicated in competition law, telecom law, insurance law, everywhere. So this is what I mean, that by the 2000, we had say accountancy profession. Several institutions required for competition were well developed. That's why it worked. But yet, Professor Bhattacharya was mentioning about competition policy. Then there's a talk of competition policy. Even today, we do not have the competition policy. Competition depends, of course, on the government's commitment. But first point is that the irrespective of government, the commitment to economic reforms and competition remains unchanged. But the support of the government to prevent how much of anti-competitive things we want to prevent depends on, it varies from time to time, but there has been no discernible difference among the governments within India. For example, competition depends on, we don't have a competition policy, we don't have a competition assessment of legislations. We have something on, we call it only 3 sections, section 3, 4, 5, cartel, anti-competitive combination, which is a very limited actually, very, very limited, deal with a very small aspect of the competition issues. Broader things remain outside the competition law. There has not been much focus on that, and the more further important is that there are, I would say, unfair. One is fair competition. We expect competition commission should ensure fair competition. That's not happening. They are trying to address only unfair competition in certain areas, but not many areas. For example, I would like to think a little macro sense that if I am paying tax, I'm an honest citizen, and another person does not pay tax, we two can't compete. He has innovative way of dodging tax. There cannot be a competition. So this is what we have not been able to prevent, or not have been able to really focus is not there, because we have limited the jurisdiction of a competition authority. I think with this I'll stop. I'll respond to the queries, whatever, if it comes. But in India, competition law, though homegrown, though we have done probably better than our neighboring countries, we have not done as well as we have done other areas of market economy in India. Particularly if I look at security, information services, telecom, airport, all those areas of reforms, even food, utility regulators, regulations of professions. In those areas, I think we have done better than this area, and probably the reason is that this is the only law which depends on the rule of origin, which still follows an adversarial model, unlike every other regulator in the country. Okay, I stop it here. Thank you. Thank you, madam, for having me here.
Thank you so much, Professor Sahu. And as usual, very rich perspectives there. And also really appreciate the comparative perspective of competition law with respect to other sort of economic regulations as well. So that's really helpful. And both you and Professor Bhattacharjee can give us sort of this really deep perspective and insight on the process of adoption and implementation of competition law, but also Samir, who's speaking next, has sort of those insights. And it's always like so enriching to hear these perspectives and also to hear sort of how your perspective of how competition law has kind of fared in India vis-a-vis other laws is interesting. So I will now sort of move on to Mr. Samir Gandhi for his perspectives on the book.
Thank you, Shilpi. I mean, it's a pleasure to be here. Of course, Saturday evening is more entertaining because of conversations like this. Amber, thank you for giving us, collective food for thought. It takes a little bit of a gentle nudge to get us all together and, to start us thinking along the lines that you have started this conversation. And look, honestly, I think, you had invited us to make this more conversational. So I will take your invitation, Shilpi. And actually, instead of, going down the line that I potentially was thinking of, maybe add to the lesson that both Professor Bhattacharjee as well as Mr. Sahu have offered us in terms of how, the context has changed. And maybe that I'll take that, in the context of Amber's book. I can't claim to have read it all. It's work in progress. Amber, I promise you I will get there at some stage. But in the meantime, what I have enjoyed reading tremendously is, I don't know, I'm going to call it same, but different, right? Given that this is Asia and given that, we have Thailand and Cambodia and all of these places in the mix as well. So I think that phraseology kind of fits in perfectly for my remarks, which is, of course, as soon as one starts reading the book, including the opening parts, I was like, hit with a strange sense of deja vu because, Amber, you start with, the cement case and arguably, that is shared trauma for some of us here in India as well, because that was practically the coming of age of the Indian Commission in many ways, right? Because it had gone down in a very aggressive fashion against what was considered to be a long-time cartel. The earlier erstwhile MRTP had taken many bites at that apple and not succeeded in, moving the needle in any which way. And lo and behold, comes our Competition Commission, chaired by the then, former Finance Secretary, Mr. Ashok Chavla, and comes out with this big bang kind of decision on involving India's big cement majors. And a lot of what the legal battle that you narrate, which ensued in Pakistan, is again something that we live or we continue to live, right? I mean, this is Indian stretchable time, so our courts go in the same way. So that's currently before the Supreme Court, and I think that's what got me thinking about the same part. There's a lot over here which in your at least the chapters that I've gone through. Where it seems that, there's, like I said, a pervasive sense of like deja vu. I've seen that before. It's happened in India. Both Aditya as well as, Professor Sahu have kind of laid out a little bit of that in the historical context. But I mean, for us, even in terms of how this law has been enforced and, what we see ahead of us in terms of the digital competition bill, I think this is, history has a strange habit of repeating itself. My sense is that we're in some sort of, a perpetual loop, right? And if you look at, the MRTP of 1969 in India and the MRTP of 1970 in Pakistan, you look at the external, internal influences which led, Pakistan had the World Bank do a study. I think India had the Raghavan Committee, which borrowed liberally from, then I think it was not 101, 102, 81, 82 or something of, the Treaty of Rome. And then you see India, promulgate its statute in 2002. Along, if you look at outside of just Southeast Asia, but you look at, and Professor Anu Bradford at Columbia was doing a paper in 2018, which I think you referred to. And at that time, I had a chance to speak, and it was empirical analysis. And I think she has a nice little map where it gives you a sense, and it's color coded, where you see how, the other BRICS countries as well. So not just South Asia, but Russia, India, China. So clearly there was an externality, right? I mean, even though I kind of want to bridge what Professor Sahu said and Professor Bhattacharya said, and saying that, yes, the WTO was very much one of the factors. It wasn't the only factor. It was very much endemic. I'd say that, with the adoption of the Marrakesh Agreement in 94, the Singapore Agreement or the Singapore Ministerial in 96, the Rao-Govern Committee comes around in 2000, you have a statute in 2002, it was almost like India was putting a little flag in the sand, saying, hold on a minute, I am not ceding my, sovereignty, because around about the same time, ironically, I joined law school, and, it was this entire debate about the TRIPS agreement and whether we should cede sovereignty by, looking at a multilateral organization was very much there. Right. So I think that this is the same part, as far as I can see, that the difference starts to percolate in the typical Indian fashion, apart from the external. When you start thinking about, the pushes and pulls of India Inc. Right. When you see that between 2002, the law got implemented in 2009. We'll speak about that in a moment. But between 9 and 11, there was a hiatus. Merger control did not come into force. So you could see that, here was India Inc., which was emerging from, the shackles of our command and control economy and industrial licensing, with the Industrial Policy of 47, the Industrial Licensing Act of 51, so on and so forth. This was our moment, right? We wanted to get out there and not buy Fiat and Ambassador cars any longer. It was our moment to kind of actually be more competitive as an economy. And I think that's why you see that instinctively the reaction for India Inc. was to kind of push back, particularly on merger control, right? So I think there was, action reaction happening in the Indian market. I think there was a strong sense of stakeholders who were pushing back. And that was pretty instrumental in terms of, the shape that our merger control provisions have, for example, taken even once they were enforced. So I think both the timelines tell the story, but even substantively, we can have that conversation another day, but substantively the rules, the way that they have been framed today, look quite different from what they are, in Europe, for example. Right. So I think that's one peculiarity. The second one, the difference is also, I think, in the conflict between, regulators in India. Right. Not novel, but I mean, in India, we have this, particular masala where you have ministries battling it out with each other. You have regulators battling it out with each other. You have the TRAI and you have the CCI. You have, sectoral regulators, etc. All of them in, to use a trade analogy, a spaghetti bowl of regulation. In this spaghetti bowl of regulation, right, there is, of course, the government, which is sitting on top and trying to move various parts around, and to try and ensure cohesiveness, to give them the benefit of the doubt, they try and ensure that each of these regulators are manned by bureaucrats, right? People who are going to go out there and carry out the mission, right? See it in a particular way. So you see that the first time that the Indian Supreme Court ever looks at, Competition Act is really in Brahmdat in 2005, where this existential question of like, look, are you a quasi-judicial body or are you a regulatory body? The so-called, the death battle, which leads to years of schizophrenia and much litigation in Indian courts, that kind of unfolds in a pretty spectacular fashion. And I think that that's something that continues to be something that we grapple with as competition practitioners. Now, the reason why I kind of point you towards these two peculiarities, which is that the inter-regulatory tussle or the spaghetti regulatory bowl, as it were, as well as this push and pull between what the executive wants vis-a-vis the government, expressed through politically appointed bureaucrats, into what is effectively a statutory regulator, which should be independent, is because we see that happening again now with the Digital Competition Bill. Right? I think we see the same story kind of unfolding in pretty spectacular fashion. You see that, yes, there is a tick box. There are, there are conversations, there are stakeholder consultation, but it's always wonderful to see, and I think Aditya and I have shared experience, at least in the context of the Competition Law Review Committee, of how you can disagree but not really disagree, right? Even in the report of the committee of the CLRC at that case, right? So I think there is this tokenism. I'm going to call it that and be provocative because we want to provoke some discussion on a Saturday evening. There is some tokenism towards consultation. Does it really move the needle? I don't know. There is a whole sale kind of adoption of what we're seeing in Europe, right? I want to call it the strange sense of FOMO, this fear of missing out, garbed in stakeholder consultation, right? Wow, I've seen this before, right? I mean, the consultation is there, but it looks like the World Bank wasn't called in. It was Raghavan Committee. We borrowed from 81, 82 there. We're borrowing from the DMA today. So Europe continues to be a strong part of our imagination, right? So I think there are things which inform our legislative process, which are informing the promulgation of the DCB. If you put in the last part about the regulatory, noodle bowl over here, you have the Ministry of Corporate Affairs, which is championing the cause because it wants to get in there, and the whole of government approach must be the whole of the MCA approach and not the whole of the METI approach, which is the Ministry of Information Technology. And in that, what's going to happen to the law, that's going to be left for us to discuss in yet another discussion.
Thank you so much, Mr. Gandhi. That was I just love the way you put things. So that was also very interestingly put, but a lot of sort of complexities coming out from what you're saying, which you kind of put in such a lucid way, calling it same, but different. But yeah, so I think we've kind of completed the Indian part of this discussion, but I think sort of what is coming out overall is, as you correctly pointed out, there is some pushback on what you and you mentioned that earlier, Amber, about sort of what you write about the Indian socialization approach. There are obviously a lot of nuances and complexities. Mr. Gandhi highlights the bureaucracy, the executive, and also sort of what he said about the merger control regulations and how they've been adopted, I thought was also very fascinating. Yeah. Will be interesting to hear what your take is on these perspectives, but we will now hear from Dr. Shahryar and his perspective with respect to Pakistani competition law and his thoughts on the book. Over to you, Dr. Shahryar.
Thank you very much. I mean, I don't know how much I can add to the already very, very rich discussion, but I just thought I'd take a step back from the nuances of competition law per se. And I thought one particular thing that I really liked about the book, which got me thinking, and I'll admit right from the start that I'm not a competition law expert, but I mean, obviously I work in the area of corporate law and commercial law. So it is of interest to me to see how regulation actually impacts economic laws and all over the the country. So one of the things that I wanted to sort of bring out in this discussion was the political economy of regulation, and specifically in looking at how competition law actually impacts society, impacts different areas of the legal framework for other areas of commercial and economic law. And so that got me thinking. And like I said, I mean, like Sameer Sahab, I'm also sort of evolving my thought process because I had a lot of other things planned to ask, but I thought, I'd sort of take a slightly more tangential and a detour from that. So one thing that really fascinated me about this book was the idea of how everything evolved in Pakistan as compared to India. And India seems to be more sort of structured. Pakistan seems to be slightly less structured, and it is a more top-down approach. But now I think I'll have to revise my opinion on that, because obviously Professor Aditya and Sameer and Professor Sahu have sort of convinced me on that it's pretty much similar. Like Sameer said, same, but different to some extent. So my then take on all of this from a Pakistani perspective is that, one thing that I thought that probably Amber can shed a light on is the idea of elite capture. And the role of the top political sort of families and the families involved in how politics and economics sort of intersect and everything. And obviously competition law lays at the intersection of all of this discussion, because obviously competition law or competition commission in Pakistan is run by sort of bureaucrats, like Samir Saab said, like in India as well. But also the role of the courts then, the enforcement of those laws, as done by the bureaucrats and the sort of the army of bureaucrats that we have in Pakistan. The other thing that I really wanted to sort of bring out here, and maybe Amber can talk about it, maybe not online, is the role of the sort of the state-run institutions within this particular context. So, I mean, the cartelization and the subsidies, the kind of sort of tax breaks that we give to state-run institutions, specifically some institutions or some companies run by certain institutions in Pakistan, which cannot be named online, but so the fact of the matter remains that, how do you sort of break those cartels? It's a very, very difficult conversation, but I think I mean, if you're not going to have the conversation here, I don't know when I'm going to have that conversation with Amber again on that particular aspect. So the idea of cartelization, the influence of the political families, and I thought it's a very interesting way to sort of look at the political economy of all of this. Regulation, specifically, right? What do we want from regulation in the first place? And that got me thinking, again, going back to the idea, because one of my areas of my research is looking at how family businesses intersect with regulation, and how they sort of, avoid a lot of regulation because they're family business, and so on and so forth. So I just wanted to sort of bring that particular perspective out, and also sort of focus on the role of judiciary here. I think we're missing out that big chunk. How does the judiciary come to play a part in all of this? And clearly, one of the differences that Dr. Amber has highlighted is that the fact that the Indian judiciary seems to be more proactive, and I'm happy to be corrected again by the Indian experts here. And the Pakistani judiciary takes a slightly more very, very measured, risk-averse approach to giving decisions. I mean, they'll give interim orders instead of actually giving final orders. So I just wanted to know if Dr. Amber can actually comment on that, and maybe the rest of the commentators can also sort of chip into that particular idea. The other thing that I thought, interestingly enough, about competition law and how it intersects with the rest of the sort of economic activity happening around in the corporate sector, which is looking at how labor law, environmental law, mergers and acquisition. And I think Professor Sahu mentioned something about the Security Exchange Board in India. And it's a very similar story in Pakistan. Again, I go back to Samir, same, different, right? We borrowed the same idea of Security Exchange Commission of Pakistan. We didn't even bother to change the name when we borrowed it from the US, right? We just put Pakistan at the end. So I think it's a very sort of common theme across the area. And I'd like to sort of, probably stop here for a minute and let Amber maybe answer those questions, because I mean, again, and I think I'll come back again to these questions if the panel is okay with it. Yeah, thank you very much for that.
Thank you so much, Dr. Shahryar, and fascinating to hear your perspective from Pakistan. Also about the cartelization of state-run institutions, it piqued my interest. I think I would happy to be corrected, but I think Indian competition law has done a decent job with that. But I would be happy to hear sort of other perspectives on that. But I think overall, but also sort of I would be interested to hear all of your views on what you thought about this comparison with India and Pakistan, and how useful it is when we think about sort of critiquing the competition law of India or of Pakistan or of any particular South Asian country. How that comparison can enrich that discussion is also something that's interesting for me for sort of this more informal discussion that we are going to have. So that's just a thought that I wanted to put out there. But now I want to give the floor to Amber to respond to all these rich comments that have come in. And it's exactly what I want, like what I thought would happen, which is that we have so much of like perspective and insight, and it's a lot to digest. And also, I would like to ask our participants if they have any questions to please put it in the chat box and or raise their hand, and we can always come to those questions as well. So over to you, Amber.
Yeah, I mean, wow, this is amazing. Thank you so much. I love the frankness with which we've had this conversation. And I expected nothing less, like you, Shilpi. I was hoping for it, and I've gotten it. So thank you very much. I just want to start with a global sort of point, and then I'll go to each person's comments. I think there's some overlap as well. So I think the global point is that we're dealing with very sort of particular type of animal, which is the transplanted law. Okay, and it can be competition, it can be a securities law. You can throw a lot of our economic laws, and when I say our, I mean in the region at this point, but also true for a lot of developing countries. We are actually transplanting laws. Now, in the South Asian context, the story is compounded, or the complication is compounded by the fact that, our legal system is in fact a transplant in its own right. It was, okay, maybe it was transplanted over 100 years ago, but nevertheless, it is a transplanted law. And what we have in our region is simultaneously this sort of indigenous what we call customary law, because we don't know where to categorize it in law books, that has coexisted. It has never gone away, which is we always have a problem of rule of law in the region. And why do we have that problem? Because the formal law doesn't extend to everybody. And therefore, we always have other things happening. And then we worry about it. Oh, our people are not really following the law. But we don't ask the opposite question, is our law representing the people? Which is something also that should be asked. But I don't want to open that can of worms, because that's history, much as I love history. But, and I'm not the sort of person who will say, well, nothing, people will push back and say, well, doesn't law become indigenized over 70 plus years? And yes, it does. It does. But I think if the roots are weak, there will always be an issue. And at some point, either the roots will fall away because those generations have died, or they will have to be addressed. But the tension remains. So that's a global point, but I will then now move on to sort of specific points that people have raised. So beginning with Aditya, your points, I absolutely agree that I have a rosier view of socialization than you do. But I'll add to that, the reason for that rosy view is not because I don't see what you're seeing, but because I'm seeing it in a comparative perspective. So when I say India has socialized, I will say what I'm really saying is, relative to Pakistan, India socialized its law. It's not an absolute point that India has perfectly socialized. I think I do try to make it, but it's just so many words if you keep saying relatively socialized, relatively more legitimate. But I do think I address that in the book. It is relatively better. And I think we can see relatively better outcomes, not absolutely better or absolutely. And I think to Shilpi, to your point, that was the advantage of a comparative study, that we could see relative differences. Whereas I think when we see India or Pakistan only in relation to the Western EU models, which is how we're used to seeing, which we call the North-South analysis, and we don't do a South-South analysis, we actually get a very different picture, maybe even a worse picture. So I think it is also important to celebrate certain successes. And this is not to say that Pakistan has not had a certain type of success also. I think it had an early enforcement success, which would only have been possible because they rammed the law through and they said, we'll never get everybody to agree. The only way to get this law is to push it through. And once we have the law, then people will recognize it as legitimate. And that's one other model of doing it. It's not wrong. It is sometimes necessary given a country's political circumstances. India, as Dr. Sahu also emphasized, had institutions. Over a period of time, it had institutions which were used to studying laws. There was a concentrated, focused effort at market reforms. And I love that phrase, marketing the reforms. I think that was a very sort of consistent drive, which was consistently followed by all state institutions. And I think this is where it wasn't that India was acting in isolation from the West, as Sameer has also pointed out, and Aditya, you have really been saying that it was the WTO was very much playing a role. This is not to be denied at all. But what is interesting is how India responds to external pressure. And I think the way India responds to external pressure is saying, look, I will do it my way. Now, I'm not even saying it's always the right way or the good way. That's also a bigger judgment, which I'm not making. I'm just observing that there are two ways to react to external pressure. One is, yes, there's pressure, please do it for me. Please help me solve this, which I would say we did in Pakistan. We went to the World Bank and we said, please give us technical assistance because here's all this pressure. We don't know what to do with it. Solve my problems. India said, okay, there's a lot of external pressure. How can we start solving it so that we look like, or we do in actual fact solve it to some extent? I see the same thing happening in the digital space as well. There is external pressure that if the EU adopts a law, if the UK adopts a law, what does that mean for India? Let India come back and start putting, Sameer, to borrow your, I'll borrow many of your phrases, but to borrow this one as well, putting your flags in the sand. The issue here is that how deeply are we studying? Are we responding meaningfully, or are we simply responding for the sake of responding? And I think that's where, Aditya, your points, and Sameer, your points also come in, that we are still sort of enamored of the Western model, and we are not indigenizing it enough. We are not aiming for the deep compatibility that we actually need. And that is certainly true in Pakistan as well. Although I might make a very controversial point that Pakistan has slight advantage in being disconnected from the global economy to some extent, because it has the space then to think of on its own and be more domestically focused rather than always thinking about what's happening in Europe, because frankly, it doesn't affect us that much. Okay, so that's, I think I've answered a lot of the points. Let me see, there was... Yeah, I think, Aditya, you also raised that point that a lot of the debates at that stage were shallow. I always wonder if they can be anything but shallow as well when it comes to competition, because I wonder, and I'm throwing that as a provocative comment, I wonder if there's something specific about competition that is contrary to the way we think in the region. So and I'm going to just point out two things, the two sort of ways in which we think. One is that we historically have been more focused on industrial policy, which is something that Sameer also reminded us, that industrial policy has been our focus, not competitive economy. As a culture, we are more focused on cooperation than competition. We still have a tribal mindset. We still have a community mindset, which means that if I'm helping somebody with the same last name as me, that's a good thing. I shouldn't be competing with, I don't know, I'm not Pakistani enough to understand all the various tribes and zaats. Maybe Sharyar can tell us that, we have this idea that a zaat, and within the zaat, the biradari, you support, you don't compete. And we see very often in our legal enforcement as well that people actually support each other across those lines rather than along the lines of law. And I think that is a counterculture that pushes back on competition enforcement. So I do wonder if there's something about competition particularly which contradicts some closely held values. I mean, I'm not an anthropologist or a sociologist, so I can't go too deep into it, but it is a question that I do consider to be important. Dr. Sahu, you in some ways confirmed my sort of socialization thesis, although you did say that the socialization was quite superficial, in which you agreed with Professor Bhattacharya. I think the important point that you make, and I want to endorse, is that, and I did want to make it in my opening comments, but I forgot, was the significance of a holistic competition policy. And I think having competition enforcement without competition policy is actually a mistake, if I can be so casual and say that, because we have, as you rightly said, we have limited the jurisdiction of the competition authority, and that perhaps is okay. But if we have a competition policy and you know where you want to take your country in that competitive space, and I mentioned that it is important to chart our priorities accordingly for competitiveness and human development, and competition has to fit into a bigger picture. And that can only happen through a competition policy. And that also says that competition cannot only be delivered through enforcement. There are many other ways of delivering it, and we are not, as a region, focused on that. I don't believe we have a competition policy in Pakistan either. I'm sure we don't have it in Bangladesh because it's just not embarked on that space yet. So, but of course, if Mr. Bhunia was here, he could have corrected me, but I'm fairly certain it's not there. Coming to Sameer, I really loved the phrase same, but different, but also because that was almost the title of my thesis. My PhD thesis was called Parallel Pasts and Divergent Destinies. It was really coming from the same space, but adopting different things. And I think that difference was where I was very interested in. The difference I focused on was the role of institutions in bringing about reform and choosing different institutions. But I think you point us to some very important differences as well, which is the difference, the industrial policy approach, which has, I think, has has really contested competition policy. It has really not allowed competition policy to take root. The interesting thing is, and I always find that with India, that a lot of spaces in which India feels contested are where India can also contribute to the global debates, because industrial policy is now fully fully back in the center of the competition debate. Should we even have competition? What is the role of, what is the space that industrial policy should have in competition policy? So I think and now again, as South Asians, I would say we are sometimes quite, too keen to shed our instincts because the West knows best. It's a competition law. They have thought about it. But I think industrial policy is very much back in the center. Pushback and merger control was something that was extremely obvious to me when I was reading the Raghavan committee report many years ago. It has been obvious to me in the delay in bringing those provisions into force. And I think the part that is missing in my research, where I think there's a gap in my own research for myself, my own understanding, is what view have we taken towards mergers in both India and Pakistan? And that is something I hope to do in the future, especially as it connects to the digital space, because I think the one concept in pure competition law that links with the digital competition regime is the idea of power, market power. And whether you call it significant market status, or you give it the name of a gatekeeper, or whether you call it dominance, that is a key position. And how are we approaching power? How is India approaching power? Is India or Pakistan actually following an industrial policy and hoping to create national champions in the guise of, we have the competition regime, but on the side, actually, we're really doing this? I think that is something that needs to be investigated further. I think one of the main points that I take away, Sameer, from your comment was that you can pretend to have consultations, but not really have consultations. So in the garb of consultations, you said we've actually had a much more top-down approach. And I think that is something for everybody to remember, that consultation, what really does it mean? I mean, Shahryar, you will remember we have Pakistani case law on this as well. What is consultation? And it can't just be somebody rubber stamping. And I think the related point is that we should have an awareness that competition will operate in a context, and not just the political economic context, but as you rightly pointed out, the context in which many other regulators and ministries are also competing for space. So unless that kind of correlation is studied, which it isn't actually, it is not really studied in the Raghavan committee report. It is definitely not really studied in the digital competition report. I think there has to be some background study. Maybe it is not for a committee which has been mandated to only look at the digital competition bill. That's beyond your remit to study that. But I think somewhere that study has to take place. And without that, you can have, again, the best formula, but will be very ineffective. I know that we have not had this kind of study in Pakistan. Okay, quickly coming to Shahryar, some really important points about elite capture, and what was that famous line from Harry Potter, that Voldemort, the one that shall not be named? I think I will name it. You talk about the army of bureaucrats, and I will talk about the bureaucrats of the army. Yes, the army, the Pakistan army has a significant stake. We talked about India Inc., but we also have Military Inc. In Pakistan. So the Pakistan army has a significant stake in the economics arena in which competition operates as well. There's nothing in the competition law that excludes the army-held institutions from its ambit. So technically speaking, as far as the law is written, as long as it's an undertaking, as long as it's an enterprise, to speak in Indian terms, the competition regime, the competition authority has the authority to take notice of what it's doing. If it's not doing that, and I think that we see a lot of that happening in Pakistan, and here I blame opaque institutional setups. A lot of what happens behind the sort of scenes is that we make executive decisions not to pursue certain claims. So what I've been observing about the Pakistani competition regime is it's actually not just singling out the army as a sort of sacred cow, but it's actually not going after any business institution. or industry, because I think it is allowing it to create a space and prosper. So that's what my observation is. The only cases that we are getting from the Competition Commission in Pakistan in recent times are on deceptive marketing practices. So in the competition regime, unlike India, we have the FTC role. Like the US, we actually have a consumer protection thing as well. So that's where we are acting. And we are acting very much in the merger space. So we are very much allowing mergers to, I think, actually, again, which goes to the germ that has entered my head is that we're using competition policy as a space to actually create market power rather than to get rid of market power in certain sectors. So I think we're going for the national champion route, which may not be wrong. I am not at all saying it's wrong. I think my job is not, as I see it at this stage of my career, is not to make a value judgment of what is right and what is wrong, but to observe what is happening and to understand where it fits in the broader picture. Because who knows what is right and wrong? That's a bigger argument. I think the other issue with Pakistan, and I think that goes to my institutional, what kind of consultations we had at the time of adopting the law. We don't have a broad-based ownership of our economic law reforms. And I think that is something that is different from India, as Dr. Sahu mentioned right at the beginning, that the ownership was there throughout. There was a policy, the LPG policy, which came out in 1991, 92, which really focused everybody's minds. Everybody had a role to play towards a certain thing. Pakistan, unlike India, has been a market economy from the very beginning. So what we've been doing is we've been chipping away on the market economy by creating exclusions, whereas because India was a fully excluded economy and it is now a market economy in the last 30 plus years, it is actually looking to how to create more of a market economy. So we have a different starting point. We're coming to it from different places. But I think where we end up is not very dissimilar. So Pakistan was a fully capitalist market economy, which is not really a market economy at all. India was a socialist economy moving towards a market economy. Both have stopped somewhere in the middle. Although I think India has made a lot of effort to become a fully market economy. So let's see if it goes there. But I hope this answers some of the questions. I've tried to keep notes, but if you have any more, I think we have some questions in the chats as well. So I'll be happy to take them, Shilpi, if you think that's the right way to go forward.
Yeah, we have some interesting questions coming up in the chat. Thanks, Amber. But before we go to the chat, just very quickly, also sort of really loved hearing your thoughts on what the panelists said. And also sort of an idea of a South Asian competition law seems to be forming in my head from what all of you said, which also sort of what you said, Amber, what Dr. Sahu said about sort of having sort of a competition law that kind of understands the fundamental nature of our economy and of our businesses. And yeah, the fact that maybe we are inherently more cooperative, or sort of in some way, sort of the way in which we operate is different. The way in which our businesses operate is different, and therefore, do we really sort of compete in the very traditional economic understanding of that in sort of different markets would be something that I think sort of is worth thinking about, because so much of our sort of the theory that the economic theory that underpins competition is obviously taken from the West, right? We don't really have our own understanding of how markets work, and I think we need to do that. So maybe sort of having more, I mean, just coming back to more practical things, maybe having more market studies to understand sort of what are the nuances of markets here, and then sort of basing competition on that. But also sort of what Dr. Sahu said, that we don't have to just have like anti-competitive agreements, abuse of dominance, merger. Like, we can think of sort of what makes our markets more open to entry, exit, and those kind of features, and then sort of think about competition regulation from that perspective. So Sami, you had your hand up.
Only because, it's Friday evening and agreeing is boring. So I'm going to disagree a little bit over here with both you and Amber. I'm not entirely certain that, this underlying pervasive kind of morality in South Asia of, we cooperate and don't compete not that it doesn't happen in South Asia, but I wonder whether it's unique to South Asia, because I mean, given that, one has seen antitrust enforcement now in a few other jurisdictions, I can say that, I mean, cartels are rampant in the jurisdictions in which have had, the Sherman Act, the Clayton Act, the Treaty of Rome, arguably in Japan, in Germany. I mean, I can think of this parallel across the board. Look, it's just more efficient, and I'll stop there, to cooperate, right? I think that's I don't know about the whole morality of it, etc. Truth of the matter, I've seen, families go after each other in India Inc. like there was no tomorrow. So I do wonder about the cooperate compete thing being Indian/South Asian.
Can I just quickly respond to that? I really appreciate you saying that, actually, because like I said, I didn't have an answer, but I've always wondered. I mean, there are scholars who have written that developing countries generally have a culture of cooperation rather than a culture of competition. The only difference, I think, between the Western cooperation and the East and sort of our cultural cooperation is that there, when they cooperate, they know they're doing something wrong. Here, when they cooperate, they know that this is anti-competitive and they do it in a different way. There, I think that is the norm. Cooperation at lower levels. I'm not talking about big corporate houses cooperating. They might have a very good sense of what they're doing, but I'm saying that grassroots kind of competition understanding is probably less. That awareness is less entrenched in our systems. We also, I think, just to add, a very big difference that we have from Western economies is that we have an informal economy. We have small traders. And competition law is not really looking at them. And I think that's a very big area, a gap, because technically perhaps there is a lot of competition. I don't know. I don't know, but I don't know because that's just never studied, that a very big chunk of our economy is actually informal. But I'm going to also stop there because I think Shilpi has better ideas of how we'll proceed.
No, thank you so much for that. So, yeah, we are a little bit short of time, so I will invite our panelists to maybe briefly make some more specific comments. I know I asked all of you to comment more specifically on sort of the role that governments play with respect to competition law, the adoption and enforcement of competition law, and also sort of the idea that Amber talks about of declining competition enforcement in India and Pakistan over the years. But I also wanted now to sort of maybe if you would like to comment, Professor, but Sameer's already talked about it, but Professor Bhattacharjee, Professor Sahu, on sort of what you think in terms of what is going on right now with respect to the deliberations on the competition bill, sort of just given how the Competition Act came about, sort of what your thoughts are with respect to sort of the similarities, differences, what we can learn from history and sort of what is happening now. So if that is something you'd like to comment on, or something more specific from the book, I leave it to you. Just brief comments because we're running short of time. So very briefly. Professor Bhattacharjee.
I've actually done my homework to answer your specific questions, but since you, like a good professor, you've slipped in out of syllabus question. Let me address that because it is topical and it is something that I've been thinking about a lot. As Sameer said, these committees are often used as legitimating devices where the ministry that set up the committee has an agenda and it goes through with the impression of having stakeholder consultation. I was party to 2 such committees. I don't think I know it was clear that the Ministry of Corporate Affairs had its agenda. But in the case of the earlier committee, the CLRC, Sameer knows, I submitted a long note, which was actually a dissenting note, which they didn't call a dissenting note. They published it as an appendix and called it my observations. So they didn't actually incorporate much of it into the final report. but at least one made one's point. In respect of the more recent committee on the digital competition bill, I again submitted a 5-page, and I think it was the lengthiest set of observations, but this time they did incorporate almost all of those into the final report, so there was no need for me to insist on including it as a note of dissent. So I think it's inevitable that with something as complicated and novel as digital competition, there will be differing viewpoints, even within a broad consensus. And I think the report does the needful. I am following very closely the vigorous debate that has ensued in the media. I'm attending different workshops and seminars where I'm usually called on to defend the bill, and I do defend it up to a point. But I say that it's not the last word on the subject, not by any means, and it will definitely need a lot of fine-tuning before it is introduced in Parliament and even beyond that. Now, to answer at least partly some of the original questions which you asked, I think the crucial one is you asked us to address the question of whether there can be an indigenous South Asian competition law framework different from that which is supposedly being imported or imposed by Western governments and agencies. I don't think so, because the core substantive features of competition law have been well established for over a century. It consists of prohibition of agreements, abuse of dominance, and mergers having anti-competitive effects. There's very little scope for variation of that. And Amber's book actually shows that ultimately, despite the very different adoption pathways, which she labels coercion versus socialization, there was, at the end of the day, emulation of the basic elements of established Western models carried the day. And as she said, there's not much scope for reinventing the wheel. We can adapt the wheel for our local road conditions, put different tire treads perhaps, but we can't really come up with a completely different approach to competition law. The local variations which we have seen will be based on institutional design in terms and procedures. That is, what is the nature of the agency, how is it appointed, what the powers will it be given, what procedures it will follow. Those have to be embedded in the very specific legal and political context of each country. So not much scope for a quote unquote South Asian law on that count. What we can consider is to share experience with scope for exemptions. And as Amber said towards the end, and that's a very nice chapter at the end of her book, in which she generously cites some of my ideas on that. Prioritization and enforcement, keeping in account the fact that we are all very poor and unequal countries with huge human development deficits. How can competition law, given the limited resources of the competition agencies, be prioritized to address anti-competitive behavior which affects these core developmental concerns? Maybe we need to share our understanding on that. But I would say first, in all these countries, we need to improve our domestic understanding of competition laws. There is very little of it. As I said, it remained elite discourse. It spread somewhat in the business media, and of course, the antitrust, very vigorous antitrust bar, which we have, but very little even in academia. I know because I engage with very few Indian economics departments teach anything relevant to the economics of competition. Even amongst the law schools, apart from a handful, including Shilpi's, where she does an excellent job. I had the opportunity to talk to her students, of course, National Law School, where both Shilpi and Samir have their early training. Only a handful, but most law schools I've talked to graduates who say they've done competition law, they don't really understand it. I am saying this as someone who has had no formal training in competition law. So we need to improve ourselves before we can hope to improve and contribute to each other. And I'm just worried that the kind of legitimacy concerns that Shilpi talks about in terms of Western agencies imposing their views, if India takes the lead on that, and I was surprised to learn that Indian advisors played a role in 4 other South Asian countries drafting. But if India pushes it beyond a point, given the fact that there are opposition parties in most of these neighboring countries who are ready to jump on their governments for imposing anything resembling an Indian big brotherly attitude, we have to tread very, very cautiously. So let that be a caveat in terms of developing a South Asian agenda. It should probably be done in terms of informal interactions like this amongst academics and think tanks and civil society without trying to influence government policies in other countries. Thank you.
Thank you so much, Professor Bhattacharjee. Professor Sahu, would you like to make any final remarks?
No, yeah, yes, we borrow the knowledge, practices, and in fact, we send people for training abroad. Particularly, I'm more familiar with the securities laws, where probably under the US funding, for about 15 years or so, every year from India, 30, 40, 50 people used to go and take training on securities market operations in United States. So nothing wrong in that, learning the way they do, but not doing the way they tell us to do. So India has never gone on that path. India has prepared its own tailor-made path on its whatever it wanted to do. And because of that, in a quite a few areas, India has gone ahead of the world. At least the areas I am familiar with. In competition law, we have not done as much as, even I told that we have not done as much as we have done in other laws in the country. But in securities laws, insolvency laws, telecom laws, I have seen these, any of these places, we have done far better. I'll give you one example to illustrate that. Dematerialization of securities. It's one of the biggest success story of Indian security market. It happened in 1995. World was not aware of this. In fact, the word demat is India's contribution to English vocabulary. And it became a model for every country, including US. They copied this model subsequently 3 years, 5 years, 10 years. So several areas there are, even in insolvency, which I was recently associated with, we have improved upon what is available in the world and done better than them so that we can become a model for others. So that has been India's general approach. We learn from others, but we improve quickly, we go ahead of the others. That's why, when I give you one data, in terms of protection of minority investors, this in World Bank's ease of doing business kind of things, on this parameter, India has been in the top 5 or 7 for last 3 decades or so. So there are areas India has moved very far ahead, though we copied or we borrowed the ideas from others. One. The second is about, I agree with Amber about the declining enforcement actions. One is that whatever enforcement actions you take, really do not move to logical end. We mentioned about the cement. We had cement cartel also, similar orders from our authority, but yet those are not concluded even today after 10, 15 years. Monetary penalties are imposed, not to be recovered. recovery percentage is hardly 1% or 2% till now. So one is the quality of enforcement action. Other is the enforcement action taken is not really implemented. And third is we also mentioned that we have focused our enforcement actions on big participants, big players, but there are something anti-competitive happening in the roads, bylanes, small cities. Because India or any economy is a market for millions and millions of products. And if you look at geographical and product markets, you run into crores of markets as if there is nothing. Everything is fine going on. There is no manipulative practice anywhere. We come across a handful of cases being handled by the competition authorities in these kinds of countries and even abroad also, even the US and America also, US and European Union also. So the problem is that we follow the model that practically we expect that a person, aggrieved person, comes with a complaint, come information, spends money, time and resources to establish his case. Then the competition authority calls the other person, gives an opportunity to tell him to explain. Thereafter, it takes a view, which we call an adversarial proceeding. That is not what a regulator works. This is how a court works. And that's why we don't receive more than 100, 200 complaints in a year, stroke information in a year. So we replaced the word complaint in our competition law in 2009 or 10 because we had started in a structure of adversarial court process, complaint based. But we soon realized, in fact, there was some court case that this model does not work. We have to move to a different model where the regulator does queries on inquisitorial proceedings, where it is the regulator versus the accused. It's not that there is a plaintiff and defendant or an informant and opposite party. That model really does not work. If you follow that model, that means essentially you are saying that let court handle these things. It is essentially court approach, traditional approach that a court follows. If you do that, you will end up with some big cases, 10, 15, 100 cases a year. But we will continue to have malpractices or misconducts in several hundreds, thousands, lakhs of markets, which will not come to our notice at all. And this is coupled with the problem in that we do not have the capacity. Regulatory capacity is a problem in all under all developing countries, and particularly in competition law. We do not understand the concept of competition assessment. We don't understand the regulatory impact assessment. So several things, the rule of origin things we don't understand, and our academia are not ready to impart this kind of training. So we have severe capacity constraint, and that's why actually to me, as much because every other law is much simpler, security law is much simpler, though it could be voluminous, but very simple to administer. The probability of the enforcement action is effective depends on two things. One is the probability of apprehending and convicting someone, and the amount of penalty attached to that. Elsewhere, with lower penalty, you achieve better success. But in a competition law, you can't achieve it because the probability of catching somebody is very difficult. And the probability of going wrong, committing mistakes, committing a false negative, falsely you get that there is false negative and you penalize an honest business person, that becomes much more damaging. So essentially our problem, I would say that we have not really developed the capacity for competition law enforcement. I'll stop it here. Thank you.
Thank you so much, Dr. Sahu. Over to you, Samir.
No, I feel like I should cede my time. I think Sharia should totally go. I've monopolized quite a bit of conversation.
Dr. Shahryar, any final remarks? Yeah, I know we're short of time. I'm sorry about.
Then that's absolutely fine. I mean, I enjoyed the conversation more than I think probably all of the audience. No, I just wanted to sort of reiterate the same thing. I think the question that you posed to me from the formal sort of list of questions that you had, and so sort of, all of my arguments have been on that particular idea. I think Pakistan needs to, specifically in the context of Pakistan needs to develop a very, very well thought out competition policy. Like Amber said, that we do not have that right now. And unless and until we have that, we cannot sort of start having proper competition law enforcement or regulation. The second thing I think, and something that I've picked up from Dr. Sahu's discussion and Sameer's discussion, is the idea of the overlap between the regulators. And I completely agree. The whole idea about mergers and acquisitions and competition law sort of intersecting, and also sort of commercial transaction intersecting. So all of those regulators have to have a umbrella idea of what they're trying to do. And therefore, competition law policy or competition law regulation can only be a part of a bigger regulatory framework that we're trying to achieve. And that brings me back to the idea of why have regulation in the first place. So I take a very political economy context of that, and then look at the aims of why we want the regulation to be there. Maybe we're changing as a society, like Amber said, that we're sort of becoming more and more sort of controlled economy, and India is opening up as a capitalist economy. Whatever the case may be, we need to have a very, very sort of well thought out competition policy before we can move on, so that we can understand why we're regulating, to what end we're regulating, and what is the outcome that we want from that regulation. And with that, I'll stop here. Thank you very much.
Thank you so much, Dr. Sharyar. So we have Amber, we have Priyanshi's hand is raised, and we have two questions in the chat. So I'll read out the chat questions, and then
I can read I actually had a quick read of the questions. The first question is fairly long. I'm going to focus on the last part of it, where I think is it Vandana? Yeah, Vandana. So I think, Vandana, your question talks about the goals of competition law, and you talk about broader set of goals. Now, the difficulty with broader set of goals is that sometimes they dilute enforcement. And what we don't want is to dilute an already very diluted enforcement. So I think the goals of competition law should not be changed, perhaps, and I agree with Professor Bhattacharya. Aditya, I agree with you wholeheartedly on this point, that we want to keep the core economics quite solid. But I think what is important and what we lack really is to understand how these goals link with our broader goals. Right. So I think, as we've been saying again and again, that competition fits into it's a part of a bigger puzzle. And what competition scholars are very guilty of doing, and I think especially in Europe, is that they start thinking of it as a self-contained system. And we only talk about competition. We only talk to competition lawyers. We forget that, but we can't afford to forget that in our context. We must. I think the reason they can forget it is because the rest of the system is working quite well, and there are mechanisms in place to make the connections. But I think we as South Asian competition scholars need to have a bigger understanding of how the goals of competition fit. I'll give you one of my favorite examples, which I think Priyanshi will also recall from our discussions previously, is, for instance, that where we fit in as South Asians, we're quite often part of global supply chains we're dealing with powerful buyers. So maybe our competition law should be more focused on regulating buyer cartels and monopsony power, abuse of dominance by buyers rather than only by suppliers. So I think those are the kind of things staying within the frame of the competition economics. How can we adapt it to our economic needs more fully? I'll quickly answer the other question as well. I hope, Vandana, that answers your question, but I'm always happy to have a further conversation on the side if you would like to. Yes, so regional cooperation, again, at the risk of echoing Aditya again and again, but I do agree, Aditya, what we really need is these kind of conversations, perhaps even more, I would say even more informed conversations about specific cases, specific experiences, specific sectors. But I'm not one to, I think I'm not a coercive person by nature, so I would never think that, we should talk to governments and tell each other what to do. Yes, India has played an important role in the spread of competition law in South Asia. I don't begrudge it, that role at all. I think it was an important role to play. I think the understanding at that time was that India would have a better understanding of what Bhutan needs, or India would have a better understanding of what Bangladeshi, language should be. There's a easier communication, perhaps. Afghanistan, Samir, you were directly responsible for some of that. I think that role is there. That a lot of that also happened at the behest of multilateral agencies. I don't think India was jumping in just because it was saying, "Oh, well, I know best." I think it was the multilateral agencies very much asking India. Maybe not in Bhutan, I don't know, but I know Bangladesh and Afghanistan's, it was definitely at the behest. But I think these less formal, I shouldn't say informal, but less formal conversations and sharing experiences is very, very important. And what will emerge, I feel, while I agree we don't need a South Asian competition law, we do have a South Asian competition voice. And I think that voice needs to emerge more strongly, and that can only happen, as Dr. Sahu said, as Professor Bhattacharya has also said, when we understand our contexts better. But we need to agree, we need to focus on our domestic contexts. There's a third question. No, that's just a thank you. Have I missed anything?
Responded to Amreen as well, although Amreen is asking whether your book is available online in India.
It should be. Absolutely should be. And I think that if you have any difficulty, Amreen, in accessing the book, please write to me. I will be happy to provide an access link. But it should be available in, I think also the hard copy should be available. So if you're attached to any academic institutions or big law firms, please order a copy. That's the right way to do it. No individual should have to buy the book. I think it's an expensive book, and I don't require individuals to buy it. I'm happy to share a PDF if that's the only way you can access the book. I mean, scholarship is more important than royalties. So if you need the book, please let me know. I'll be more than happy to share it.
We're absolutely out of time. Priyanshi had a question. Priyanshi, can you ask it in like 20 seconds? I'm so sorry.
Yeah, thank you so much. Am I audible?
Yes.
Okay. So my question is more general in the sense that, yeah, we have discussed a lot about the digital competition bill, but then this comes from the recent discussion I was having with one of my colleagues, and he asked me, what's new in India? What's happening on the competition law front? And how is India looking at all these problems that are there, issues in the digital sector? And then I happened to tell him that, yes, there's a lot happening. The Competition Act was recently amended, and then the digital bill is also coming up. The draft is already here. So, but then when we actually look at the bill, we do see there's a designation for the digital enterprises that we have proposed, systematically significant digital enterprises. And so there is this adoption that is happening. The adoptive process is there, and then we come to the thresholds, and then we come to the factors that we will look at, the Competition Commission would look at, even if the thresholds are not met. So in this context, your views on how this placement, like thresholds and then opening it to number of factors, and then in the end opening it to further more factors if Competition Commission feels it appropriate, does this approach allows enough room to allow the new law or the adoptive strategy that we are looking from EU to align it with the social, economic, and political goals that we are trying to achieve? So, or in the drafting, do we require anything else to make it a more workable model? So, although we have thresholds, we have factors, but what else would be required, if at all, to align it with the social and economic and political scenario that is in India? Because we have discussed that it's still less pervasive when it comes to small and medium enterprises. It's not reaching to the grassroots. So how, in that sense, a new digital competition bill would contribute, and what else should we look at? Just a brief comment on that. Yeah, thank you.
Is this question asked of me? So luckily I can give a very brief comment, which is
Yes.
that I think that, I mean, the way what I've read of the bill, I think, yes, it is very much modeled on the EU rather than the UK. I think at this point, it would be perhaps not necessary to make too many acclimatizing changes to it, because I think that it's much more of a technical dispensation rather than a social document. I think the law has to be supplemented by these policies and these understandings. I don't think the law itself needs to be changed at this point, right? This is also just a first cut, as Aditya again mentioned in his earlier comments, that these are that a lot more will have to be done and it will get evolved. I think what is important is the process that the bill is going through, which is that it is being debated everywhere. It will be debated in Parliament as well. And that process itself will create more acclimatization. But also, I think too much, again, if you decide to acclimatize it too early and again in a top-down kind of a way, how good is that? What value does that have anyway? So that's my very quick answer, but I hope that answers it somewhat.
Yeah, that was a quite a complex question, and I think something that maybe we need to spend a lot more time discussing. But I have already sort of taken up a lot of the time of our esteemed panelists, and I have so very much enjoyed this discussion, and sort of there's just so much to take in that I think I have to spend 1 hour just to make sure I've absorbed everything that all of you have said. So it was so fascinating to hear everyone. Thank you so very much for taking the time to read Amber's book, to sort of give us your invaluable feedback. And I really look forward to maybe having more such conversations with all of you. It was absolutely sort of different perspective, different takes. And we do need to have sort of broader conversations as Amber says, not just limited to the competition community in South Asia. We need to have broader conversations on competition issues with the broader set of scholars and practitioners as well. So this was so fantastic. Thank you so much. On behalf of Jindal Global Law School, I'd just like to thank everyone for being here and enjoy the rest of your Saturday evening. And I look forward to having you again for similar discussions. Thank you so much.
Can I just thank everybody before you sign off, a personal thank you to all the panelists. All your comments enriched me, and Shilpi, thank you so much for organizing it.
Thank you, everyone.
Sorry, I couldn't give you the last word, but it was short of time.
Thanks.
Thanks, everyone.
Thank you.
Thank you.
Thank you. Thank you, everyone.